You know that feeling when someone tries to flex authority they don't actually have? Well, Patricia Whitmore, president of Lakeside Estates, HOA, was about to learn that lesson the hard way. She stood on my dock, clipboard in hand, designer sunglasses perched on her nose, demanding I remove my modest fishing boat from community waters. What she didn't know was that I didn't just live by the lake, I owned every drop of water in it. And her precious fishing club? They'd been trespassing for 3 years. Before we dive in, let me know where you're watching from today. The morning started like any other Thursday in June. I was sipping coffee on my back porch, watching the mist rise off Carter Lake. Yes, it bears my family name for good reason. When I spotted Patricia Whitmore's white BMW pulling into my driveway, at 7:30 a.m. no less. The woman had a talent for showing up at the most inconvenient times with her manufactured emergencies. "Ethan!" she called out, her voice carrying that particular pitch reserved for people who believe their problems are everyone else's priority. "We need to discuss your boat situation immediately." I set down my mug and walked around to meet her, already knowing this conversation wasn't going to end the way she expected. Patricia stood there in her perfectly pressed khaki pants and pristine white polo, looking like she'd stepped out of a country club catalog. Behind her, I noticed two other HOA board members lurking by her car. Moral support, apparently. "Morning, Patricia. What can I do for you?" She thrust her clipboard toward me with the dramatic flair of someone serving a legal summons. "This is a formal notice requiring you to remove your watercraft from community lake access within 72 hours. Your boat is in violation of HOA regulations regarding recreational vehicle storage in common areas." I glanced at the document. 3 pages of official-looking nonsense, complete with references to community bylaws and environmental protection codes. Someone had put real effort into making this look legitimate. "Community lake access?" I asked, genuinely curious about her interpretation of property boundaries. "Don't play dumb, Ethan. That dock extends into community waters, and your boat is blocking access for other residents. The Lakeside Fishing Club has filed multiple complaints about your boat interfering with their morning activities." Ah, the fishing club. 23 members strong, led by Patricia's husband Gerald, who fancied himself some sort of bass fishing expert. They'd been launching their boats from various points around the lake since before I moved back to settle my father's estate. Nice folks mostly, but they'd gotten comfortable with assumptions about public access that were about to be corrected. "Patricia, I think there might be some confusion about—" "There's no confusion," she interrupted, her voice rising. "The lake is community property, clearly stated in our HOA charter. Every resident has equal access rights, and your permanent mooring violates those rights. Either you move that boat voluntarily, or the HOA will take enforcement action." Behind her, board members Janet Morrison and Steve Kellerman nodded along like synchronized swimming judges. Janet held her phone up, apparently recording our conversation for documentation purposes. Steve clutched a folder thick with what I assumed were more official-looking papers. "What kind of enforcement action?" I asked. Patricia's smile turned predatory. "Fines, liens, legal action if necessary. The HOA has broad authority to protect community interest, Ethan. Don't test us." I couldn't help but admire her confidence, misguided as it was. She'd clearly done her homework on standard HOA enforcement procedures. Too bad she'd skipped the most important research, actually checking who owned what. "Can I see the HOA charter you mentioned, specifically the part about lake ownership?" She huffed, apparently insulted by my request for documentation. "It's public record, Ethan. The lake was designated as community amenity space when Lakeside Estates was developed. Every property deed references shared lake access rights." "And you verified this with the county assessor?" "We don't need to verify obvious facts. The community has used this lake for recreational purposes for over 15 years. That establishes clear precedent for shared ownership." I almost laughed. Patricia had confused community usage with legal ownership, a mistake that was about to cost her fishing club their favorite weekend spot. "Here's what I'm going to do," I said, pulling out my phone. "I'm going to give you 3 days to research actual property ownership records. After that, we can have a more informed conversation about who has authority over this lake." Patricia's face reddened. "Are you threatening the HOA board, Ethan?" "Not threatening. Just suggesting you verify your facts before making demands. You might be surprised what you find." She spun around, heels clicking angrily on my driveway pavement. 72 hours, Ethan. Move the boat or face the consequences." As her BMW disappeared down the street, I pulled up the contact information for my attorney. Time to dust off some old family documents and prepare for a conversation Patricia Whitmore would never forget. 3 days passed, without any boat moving, much to Patricia's visible frustration. I watched from my kitchen window as she drove by twice each morning, slowing down to confirm my 18-foot Alumacraft remained exactly where I'd moored it. Her persistence was almost admirable. Friday morning brought the expected escalation. This time, Patricia arrived with reinforcements, the entire 5-person HOA board, plus Gerald and 3 other fishing club members. They formed an impressive semicircle on my front lawn, looking like they meant business. "Time's up, Ethan," Patricia announced, waving a thick manila envelope. "Since you chose to ignore our reasonable request, we're implementing immediate enforcement measures." Gerald stepped forward, trying to look authoritative despite his cartoon fish print shorts. "Ethan, buddy, this doesn't have to be adversarial. We're all neighbors here. Just move the boat to your driveway, and we can put this behind us." "Appreciate the suggestion, Gerald, but I think there's been a fundamental misunderstanding about lake access rights." Patricia opened her envelope with theatrical precision. "We've done our research, Ethan. The lake is clearly designated as community amenity space. Here's documentation from the original HOA filing, county development approval, and 15 years of community usage establishing legal precedent." She handed me a stack of papers that looked impressive at first glance. HOA incorporation documents from 2008, county development permits, even some photos of previous community events held around the lake. Someone had invested serious time building this case. I flipped through the pages, noting several interesting details Patricia had apparently overlooked. The HOA incorporation listed lake access rights, but made no claim to ownership. The county development permits referenced adjacent community access to existing water features. Most telling, every document carefully avoided claiming the HOA owned the actual lakebed or water rights. "This is certainly thorough," I said, handing the papers back, "but I noticed something missing." "What's missing is your compliance with community regulations," Patricia snapped. "What's missing is any documentation showing HOA ownership of the lake itself. These papers establish development around the lake, access rights to the shoreline, even permits for community docks. But nobody ever bought the lake." Janet Morrison, the board secretary, consulted her notes. "The lake was included in the original property development. It's common amenity space." "Included how? Show me a deed transfer, a bill of sale, anything documenting the sale of water rights." Uncomfortable glances passed between board members. Gerald shifted his weight, looking less confident about their legal position. "Ethan," Steve Kellerman interjected, "you're getting caught up in technicalities. The community has treated this as shared space for 15 years. That creates legal obligations." I nodded thoughtfully. "You know what, Steve? You raise an interesting point about legal obligations. Let me ask you something. Has the HOA been paying property taxes on the lake?" Silence stretched across my front lawn like morning fog. "Property taxes?" Patricia asked, her voice losing some of its earlier authority. "Sure. If the HOA owns this lake as community property, you'd be responsible for annual property taxes on approximately 47 acres of water surface, plus lake bed. That runs about $3,200 annually in this county." More uncomfortable silence. "We pay taxes on common areas," Janet offered weakly. "Right, but this specific property, the lake itself, appears on county tax records as parcel number 847-293-031. Has the HOA been receiving tax bills for that parcel?" Patricia's clipboard sagged in her hands. That's not how community amenities work. Actually, it's exactly how property ownership works. Someone owns every piece of land in this county. Someone pays taxes on it. Someone holds legal title. I paused, watching realization dawn on several faces. Would you like to know who owns Carter Lake? Gerald spoke up first. Who? I pulled out my phone and opened the county assessor's website. According to current records, lake ownership transferred to Ethan Michael Carter on March 15, 2019, following probate settlement of the Thomas Carter estate. I turned the screen toward them. That would be me. The silence that followed was broken only by someone's ringtone playing a cheerful country song. Patricia stared at my phone screen, her mouth opening and closing without producing sound. Behind her, the fishing club members began what looked like urgent whispered consultations. "This is impossible," she finally managed. "The HOA has clear documentation." "The HOA has documentation establishing community access rights to the shoreline," I corrected. "Very different thing. Your development agreement gives residents the right to use designated lake access points for recreational purposes. But the lake itself, the water, the lake bed, the fishing rights, all that belongs to whoever holds title to parcel 847-293-031. Gerald found his voice. "So you're saying we've been trespassing for 3 years?" "I'm saying you've been using my lake without permission for 3 years. Up until now, I've been happy to let that continue. Seemed neighborly." Patricia's face cycled through several shades of red. "This is ridiculous. You can't own a lake." "Tell that to the county assessor, or the State Department of Natural Resources, or my property insurance company, who sends me annual premiums for lakefront property coverage." I watched Patricia Whitmore's authority crumble in real time. Her confident demands replaced by the dawning understanding that she'd just threatened the person whose permission she needed for her husband's fishing hobby. Word spread fast through Lakeside Estates. By Sunday morning, I'd received visits from 12 different neighbors, each approaching with varying degrees of embarrassment and curiosity. Most were genuinely apologetic once they understood the situation. A few seemed skeptical until I showed them the property deed and tax records. Patricia, however, had chosen the path of escalation over retreat. She arrived Monday morning with what appeared to be legal backup: a sharp-dressed man in his 50s, carrying a leather briefcase and the unmistakable air of someone billing by the hour. "Ethan Carter?" the man asked, extending his hand. "I'm Robert Hayes, attorney representing the Lakeside Estates HOA. We need to discuss your interference with established community rights." I invited them onto my porch, genuinely curious about their legal strategy. Patricia sat ramrod straight, radiating vindicated energy, while Hayes opened his briefcase with practiced efficiency. "My client has provided documentation establishing community lake access rights dating back 15 years, Hayes began. "Your recent claims of ownership appear designed to circumvent established HOA authority and deny residents their legal rights to community amenities." He slid a legal document across my patio table. "This is a cease and desist order requiring you to remove all barriers to community lake access and acknowledge HOA authority over community waterways." I read through the document, impressed by its official appearance and creative interpretation of property law. Someone had invested real money in this intimidation attempt. "Interesting approach," I said. "But you've made the same mistake Patricia made, assuming community access rights equal ownership." Hayes consulted his notes. "Mr. Carter, adverse possession laws protect community rights established through long-term usage. Your residents have openly and continuously used this lake for over 15 years. "Adverse possession requires usage without permission," I replied. "But there's never been any restriction on lake access. No fences, no signs, no objections from previous ownership. That's permissive use, not adverse possession." Patricia leaned forward. "You're splitting hairs, Ethan. The community has established legal rights. The community has established exactly what their development agreement grants: access to designated shoreline areas for recreational purposes. That doesn't create ownership of the water itself." Hayes tried again. "Mr. Carter, the HOA charter clearly designates the lake as community amenity space." "Show me," I interrupted, pulling out my own folder. "Show me any document where Thomas Carter, the previous owner, transferred lake ownership to the HOA or designated it as community property." I opened my folder and spread out the relevant paperwork. Here's the original property deed from 1978 when my grandfather purchased Carter Lake from the state. Here's the transfer to my father in 1995. Here's the probate settlement transferring it to me in 2019. 47 years of continuous Carter family ownership. Hayes examined the documents, his confidence visibly wavering. Patricia watched him with growing alarm. "These deeds are for the surrounding property," Hayes said finally. "They don't specifically mention water rights." "Actually, they do." I pointed to specific language in each document. "Includes all water rights, mineral rights, and riparian access associated with the said property." Pretty standard language for lakefront property sales. The silence stretched uncomfortably. Patricia broke it first. "This is absurd! You can't just own a lake and deny community access." "I'm not denying community access," I said calmly. "I am clarifying who makes decisions about lake usage. And right now, I am making the decision to revoke fishing privileges for the Lakeside Fishing Club." Patricia shot to her feet. "You can't do that!" "Actually, I can. Private property owner's prerogative." I turned to Hayes. "Your client has spent the last week threatening legal action against me for using my own property. Her husband's fishing club has been using my lake without permission. Time for some boundaries." Hayes packed his briefcase slowly. "Mr. Carter, I think we may have approached this situation incorrectly." "You approached it by threatening someone who was happy to share," I said. Patricia turned a non-issue into a property dispute. Actions have consequences. After they left, I walked down to my dock and began installing the signs I'd ordered over the weekend. Professional aluminum signs with clear, legally appropriate language. Private property, lake access, by permission only. Unauthorized watercraft will be towed. Within an hour, my phone started ringing. Gerald called first, his voice strained with panic. "Ethan, buddy, we need to talk. Patricia said you're banning the fishing club?" "Not banning, Gerald. Just clarifying that lake access is a privilege, not a right." "Come on, man. We've been fishing here for 3 years. Some of these guys built their whole retirement plan around morning fishing trips. Should have thought about that before your wife decided to play hardball with the property owner." Patricia doesn't speak for the fishing club. She was trying to protect community interests. Patricia was trying to flex authority she doesn't have. Now she gets to explain to 23 fishing club members why their favorite spot is off limits. The calls continued throughout the day. Fishing club members, HOA board members, neighbors I'd never spoken to, all trying to negotiate some middle ground. But Patricia had made this personal, and personal actions deserved personal consequences. Tuesday morning brought the most interesting call of all. "Mr. Carter, this is Detective Sarah Mitchell with the County Sheriff's Office. We've received reports of a property dispute involving lake access rights. Could we schedule a time to discuss the situation?" "Of course," I replied. "Though I should mention, you might want to bring someone from the assessor's office. There seem to be some questions about property ownership that need official clarification." Detective Mitchell arrived Thursday afternoon with County Assessor David Park and what appeared to be enough paperwork to resolve property disputes for the entire county. They set up in my dining room, spreading documents across the table with professional efficiency. "Mr. Carter," Detective Mitchell began, "we've received multiple complaints regarding restrictions on community lake access. The HOA claims you're violating residents' rights to community amenities." "I appreciate you looking into this," I replied. "But first, could Mr. Park clarify actual ownership of the lake for everyone involved?" David Park, a methodical man who'd apparently dealt with similar disputes before, opened his laptop and pulled up the county's GIS mapping system. Parcel 847-293-031 comprises 47.3 acres of water surface and associated lake bed. Current owner is Ethan Michael Carter. As of March 2019 probate settlement. Annual property tax assessment is $3,247. Detective Mitchell took notes. And the HOA's claim to community ownership? The HOA owns several parcels designated as common areas, shoreline access points, a community dock, the boat launch area, but they've never held title to the lake itself. So Mr. Carter has legal authority over lake access? Absolute authority within environmental regulations. It's private property. Patricia Whitmore chose that moment to arrive. Apparently, having been informed of the official meeting, she swept into my dining room like she owned it, Gerald trailing behind with obvious reluctance. "Officer, thank goodness you're here," Patricia announced. "This man is trying to steal community property and deny residents their legal rights." Detective Mitchell consulted her notes. "Mrs. Whitmore, according to county records, Mr. Carter owns the lake. Community access appears to be a privilege he's extended, not a legal right." Patricia's face reddened. "That's impossible. The lake is community property. We have documentation." "You have documentation establishing shoreline access rights," Park interrupted. "Very different from lake ownership. Your HOA owns 3 parcels totaling 2.1 acres of shoreline property. Mr. Carter owns the water." The room fell silent except for the scratching of Detective Mitchell's pen. "Mrs. Whitmore," she continued, "threatening legal action against a property owner for using his own property could constitute harassment. Making false claims about community ownership might be considered fraud." Gerald stepped forward. "Officer, we never intended to cause problems. The fishing club just assumed." "The fishing club made reasonable assumptions based on 15 years of permitted usage," I interjected. "Patricia made unreasonable demands based on false legal claims." Detective Mitchell closed her notebook. "Here's how this resolves. Mr. Carter has absolute legal authority over lake access. Any community usage occurs at his discretion. Mrs. Whitmore, any further threats or false legal claims could result in harassment charges." After the officials left, Patricia sat slumped in my dining chair, looking smaller than I'd ever seen her. Gerald stood behind her, his hands on her shoulders in a gesture of support that couldn't hide his obvious embarrassment. "Ethan," Gerald said quietly, "Patricia made mistakes, but she thought she was protecting community interests. The fishing club, these guys aren't wealthy. This lake is the highlight of their week." I studied Patricia's defeated expression, remembering my father's advice about knowing when you've made your point. "Here's what's going to happen," I said finally. "The fishing club can continue using the lake, but there are new rules. No more assumptions about community ownership. Lake access is a privilege I'm extending, not a right you're claiming." Patricia looked up, hope flickering in her eyes. "However," I continued, "Patricia needs to publicly acknowledge her mistakes and apologize to the community for the confusion she created." "Public apology?" she whispered. "Next HOA meeting, full disclosure about property ownership, acknowledgement of legal errors, and formal apology for threatening a property owner who was graciously sharing his private lake." Gerald squeezed Patricia's shoulders. "That's fair, Ethan. More than fair." Patricia nodded slowly, her authority permanently deflated, but her husband's fishing privileges preserved. "And Patricia," I added, "next time you want to flex HOA authority, maybe verify you actually have that authority first." 6 months later, Carter Lake remains open to community fishing, with new signs clearly identifying it as private property used by community permission. Patricia completed her public apology with grace, though she resigned from the HOA presidency shortly afterwards. Gerald sends me Christmas cards now, and the fishing club members wave respectfully when they launch their boats. Sometimes the best way to teach respect for property rights is to demonstrate what happens when you take them for granted. Patricia Whitmore learned that lesson the hard way, but she learned it completely. The lake remains peaceful, the fish are still biting, and everyone now understands exactly who makes the rules about Carter Lake access. Some battles are worth fighting, especially when they end with better neighbors and clearer boundaries.